Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-7050 et al. Stacia Hall et al. Appellants versus District of Columbia Board of Elections. Mr. Hayek for the appellants, Mr. Leach for the appellee.
Hey, Mr. Hayek, you may proceed when you're ready.
Your Honor. May it please the court, Chris Hayek for plaintiff's appellants. I would like to begin by briefly discussing the stakes of this case. It might not seem a big deal if a few hundred aliens vote in DC and maybe never affect the outcome of an election. But there's nothing wrong but if there is nothing wrong constitutionally with this law, there would be nothing wrong if, say, California-led aliens, including illegal aliens, vote in statewide elections, even federal elections. States, after all, have the right to determine voter qualifications in federal elections, though they can't do it in a way that violates constitutional rights. Whether good or bad, such an action by California would certainly be consequential, and the scenario is not terribly far-fetched. If this court says there's no constitutional right violated by letting aliens vote, they might try it.
Is this case based on the election of November 5, 2024?
Is this case what?
Based on the election of November 5, 2024.
It's based on that. It's also based on upcoming elections, imminent harm. The question on the merits here is simply this: do the people, meaning U.S. citizens, and the Supreme Court has rightly equated the two in this context, have a constitutional right to govern themselves? It seems axiomatic that they do, and the Supreme Court has stated this axiom in holdings. The right to citizen self-government is logically implied by the nature and presuppositions of the Constitution. By its nature, the Constitution is a blueprint for a democratic republic, and thus presupposes the basic theory of democratic self-rule. For the Supreme Court, obvious consequences of this basic theory are that citizens comprise the self in self-government, that aliens by definition are not part of the self-governing body politic, that the people have the right to be governed by their citizen peers, and that the right to govern, and thus the right to vote, because that's how the people govern themselves, is reserved to citizens.
I wonder if you might focus
Also,
at the threshold on the standing point that the district court, that it was dispositive in the district court, the theory for standing.
Yes, on standing, there is clearly an injury here to every plaintiff because the right to citizen self-government has been violated, and their power, each plaintiff's power of citizen self-government has been reduced, if only fractionally at this time.
So one thing that would be helpful, it's not entirely clear to me whether the harm from the distinct citizen self-government theory is any different from the vote dilution harm. In your, I guess it was in the reply brief, you talked about a harm of having to vote alongside non-citizens.
Right, that is a violation of the right to vote in an election in which only citizens vote.
Is that an associational claim, or is it just, because one could, for example, if one thought that the vote dilution was a harm, and there are, questions about that, but if it were, then that harm would presumably support standing to raise the claim of citizen self-government. But I was taking you to be also suggesting some other harm, injury in fact, as a basis for standing?
Right, the violation of the right to citizen self-government here proceeds through vote dilution. It's the same thing in the sense that your vote is, your power of citizen self-government is diluted because citizens share the vote.
So it does, you put it nicely, it proceeds through. So for purposes of standing, we're looking at a vote dilution theory. And typically when the Supreme Court or courts of appeals have recognized vote dilution. They've required a point of comparison, and that the district court here said, everybody who's a voter has equal votes. So it's unlike gerrymandering or malapportionment where you can point across a line and say, my vote's worth less. And so your point of comparison for your vote dilution theory is
that it's not every voter in DC who's injured by it. It is only citizen voters.
so the point of comparison, it's the votes of citizens are diluted compared to what?
To the votes of, to their former share of the electorate.
Okay, so the point of comparison is the the qualified voter pool before the law that you're challenging.
That's right, Your Honor.
So it's a temporal comparison rather than a geographic.
Yes.
That whole discussion is on the merits though, correct?
Which discussion, Your Honor?
Discussion you just had with Judge Pillard.
That was about standing. Though I was addressing the merits previously.
So yeah, I was asking about standing, and I took your answer to be that the harm is, they're challenging the law and they have a basis to challenge it because compared to the situation without the law that they claim is unlawful, claim on the merits is unlawful,
Right.
their current voting power is diluted.
Yes.
And do we have a case in which that kind of before and after, as opposed to here and there, is the point of comparison?
The case cited in our brief about the non-resident voters voting in a city, non-resident property owners, that was decided, in favor of the plaintiffs, even though it was a rational basis test that was applied because being a member of a.
Well, the Michelle case seems, the language in the opinion seems directly on point.
Our decision in Michelle.
Oh, Michael, yes. You certainly have that. I mean, that shows that it's not, what happened there is that each individual state voter's right to vote for a House of Representatives of 435 voting members was reduced equally, but they all had standing because they were all injured. But there were other voters in the country that voters in DC had their votes expanded. They got to vote for voting representatives.
Yeah, there were two standing questions in the case. One was the congressman, which Vanderjagt settled, and the other was the individual voters.
Yes.
That's why the case is quite analogous to this one. And the court held that the individual voters had standing in that case.
Yes.
Because their vote was being diluted.
Yes, Your Honor. And it's very similar to this case, and it shows the what the law is in this circuit as opposed to, say, the Fourth Circuit.
And then how do you distinguish Daughtry versus Carter, which was the case of ours upon which the district court principally relied?
I would distinguish it as there, the plaintiffs failed to show that their vote was even diluted. They said it might be diluted, but it was too speculative. You didn't know when where these people who had returned were going to be living, and whether they lived in plaintiffs' districts, and whether they would actually lose any voting share in any actual election.
And the district court said, well, I'm not relying on the speculativeness part of the reasoning. I'm just relying on the rejection of vote dilution theory in that case. Well,
I think the district court quoted the case right. It said that not every claim of vote dilution is a states a claim for an injury, and that's true. I mean, they claim vote dilution, but they didn't show it.
Mm-hmm. So there's a lot of cases that claim vote dilution in which courts have said no standing, like the bunch of the voter fraud cases from the 2020 election, Bognet, Wood, Maryland election integrity. How do you distinguish the assertions of vote dilution as a ground for standing in those cases from?
Well, I would just, one way to distinguish it is that some of those cases, like the Fourth Circuit one that was, that the defendant put in supplemental authority is, should have been dismissed for failure to state a claim on the merits because there is no right to have a perfect election and that's what they were claiming.
But for purposes of standing, would we put ourselves in conflict with the standing analyses in those
Well,
cases?
I think in a way, Your Honor, it could have been dismissed on standing, but for a different reason, because the right claimed is not legally cognizable.
The right claim, the correct claim?
Right. Because it's, there was actual injury, even if very small. Their vote share was reduced by these unlawful votes, but that injury, in fact, is not legally cognizable because if the court recognized such rights, democracy would grind to a halt.
Sounds a little more policy argument than a.
I mean, you couldn't have,
standing argument.
right. You couldn't have a, perfect election, or you couldn't have any elections. No election's perfect.
Well, is it, once the election is conducted, I mean, there they weren't challenging, as you are, facially a statute. They're challenging what they perceive to be failure to enforce, or the Supreme Court was it the Pennsylvania case, Supreme Court's decision? They said that should have been the state legislature. So in each of those cases, it's sort of a claim, yeah, that dilution is mixed in there, but that there should have been enforcement where there wasn't. So it does seem to verge more over into a citizen's concern that the law is not being applied. So it's
Your Honor, I mean,
more of the general grievance.
right.
Feeling. Is that part of your argument or not?
Well, there's I think so. There's they're alleging an illegality. They should have enforced it better. Shouldn't have allowed these illegal votes to be cast. But they don't have a right to
With enforcement of the law.
they're not injured by the enforcement of the law because they don't have a right to a perfect election.
I was just going to say, what cases do you rely on specifically for the right to citizen self-government?
The main one is Foley versus Connolly.
Foley seems quite contrary to your position because it talks about it's permissive for New York to limit state troopers to citizenship. And in fact, it's a limited category of jobs and.
Well, the reason these statements about citizen self-government and the right to govern is reserved to citizens and so forth are holdings is that the court then goes on to say that the practical consequence of these principles is that these laws don't offend the Equal Protection Clause. And that's true. That's all the purpose that the court put to those principles in that case. But the principles that it used to decide the case to reach its judgment are still holdings of the court.
On your merits argument, is your substantive due process claim and your complaint the same as the claim you've developed more in your appellate brief about the constitutional right to citizen self-government?
Yes, I think the substantive due process claim is I did not concentrate on in the briefs here. It's because it relies on a right being deeply rooted and relies on history a lot. But there's other ways
for citizen self-government that I take it that you're making this argument because in support of your position that were we to reach the merits, that strict scrutiny applies rather than rational basis review. Right? That's what's at stake there is.
No, I don't think you do tiered scrutiny for a violation of a right like citizen self-government.
That's what I'm saying. So if you're trying to establish that right because
then if it's up or down.
It's fundamental right, and then it becomes strict scrutiny. But isn't the theoretical route to recognition of citizen self-government precisely the analysis provided by substantive due process?
No, because it's an unenumerated right that's not protected by implication in the due process clause. but it is a logical consequence of the Constitution.
So you're positing a separate category of unenumerated rights that we don't analyze through the substantive due process.
Exactly, like the right to privacy, Your Honor. That was big until recently, at least.
I thought that was analyzed through substantive due process.
No, I think it came out of a number from emanations from various parts of the Constitution, including the Ninth Amendment. And the Ninth Amendment, it says that the existence of rights enumerated, the enumeration of rights protected by the Constitution in the Constitution should not be construed to deny or disparage other rights that may be retained by the people. And I would say other rights that, if they're real at all, are protected by the Constitution. The Ninth Amendment seems to indicate that there may well be other rights that follow from the Constitution.
And you're saying that we don't discern those through the substantive due process analysis of whether it's deeply rooted.
Those are some, because and the Supreme Court has stated how you were supposed to determine those rights. But other rights that might fall from the structure of the Constitution, they might be presupposed by the Constitution because it's a blueprint for a democratic republic.
They would presumably easily meet the substantive due process analysis, wouldn't they? Seems like that's very much framed to embrace just such rights.
I think it's deeply rooted in the nation's history because it is presupposed by the Constitution, and that the exceptions to it historically have been, well, especially early on, say Massachusetts, didn't have an explicit citizenship requirement for voting. But John Adams, who wrote the Constitution, wrote in the Constitution that, in this Massachusetts Constitution, using the term citizens and people interchangeably in the preamble. And it never says non-citizens can vote. It simply says that to vote, you have to have lived here a certain number of years and so forth. And at that time, nobody knew. There was no authoritative statement of who was the United States citizen. I mean, on July 2nd, 1776, when the Declaration of Independence was, or rather when independence was voted on, everybody in that room and outside in the country became an American citizen, but not, except for people, I guess, who were just visiting or who were British soldiers on American soil. And so it remained unclear just who had become citizens for quite some time. So it was impossible for John Adams to put in a citizenship requirement, a U.S. citizenship requirement into the Constitution.
You also argue that the law, the DC law, imposes a facial classification based on citizenship or nationality.
Yeah.
Where is that in the text of the law? I don't entirely follow that line of argument.
Well, they dropped the citizenship requirement. So,
Okay, so that's taking away a line.
Right, and that means that non-citizens can vote.
Right.
And
Well,
that it means that logically.
Under equal protection, we're looking at a classification.
Right.
And we're trying to decide, is this classification unconstitutional? And this law doesn't classify
Well, it
based
classifies.
on national origin or on citizenship.
Well-
It decides not to.
Well, if this law, right, but if this law is if you take the text of this law, it follows necessarily that non-citizens can vote.
Yeah,
So
as can citizens. So there's no distinction between the ways that they're treated.
right, and I would say that that's on its face. I mean, just what it means is that non-citizens can vote. They might as well have said so, because it does mean that. Because it's impossible for that to be the law and for non-citizens not to be able to vote.
So the men at the Virginia Military Institute have standing and a equal protection claim subject to heightened scrutiny to argue that the women should not be part of the student body on that theory.
Because men are a protected class.
Yep.
And so the only thing that protects that is prevents that kind of lawsuit is the idea that it's not they dropped a distinction rather than making a classification.
That's the argument that I wanted you to respond to, because that's what DC argues that it did here.
Right. I think that even if they have a case, maybe they do have a case. It's just that it doesn't meet, it meets strict scrutiny to allow women.
Mhm.
It serves a compelling government interest.
If we were to decide that this statute is subject to rationality review rather than heightened scrutiny, what's your strongest argument that you nonetheless prevail on the merits?
There's no interest the district could claim that can overcome a competing or countervailing compelling interest in preserving citizen self-government and the sovereignty of the people.
But the presumption of the question, just hypothetically, is if we didn't accept your fundamental right to citizen self-government argument, then you can't smuggle it back in by saying, well, that's a compelling interest, right? So if we say that's not a compelling interest, that's not a fundamental right, but nonetheless, what I'm looking for is any argument, and this may not be your case, I didn't see this in the brief, but that it's irrational or doesn't even meet the minimal level of scrutiny.
Well, it's irrational to, there's no argument for why illegal aliens are permitted to vote. The whole thing is irrational.
They do make an argument that they say if people are working here, paying taxes, sending their children to school, they're in a practical sense part of the community, that there's an interest in having people be, engaged and feel that they belong. So, and what I'm looking for is if we assume rationality review applies, what's your response to why that's not a rational basis?
Well, I would go back to saying that even if there's no right to citizen self-government, the Supreme Court didn't hold that there was. It certainly held that there was a powerful interest in citizen self-government.
No.
Right. Thank you.
Okay.
May it please the court. Brian Leach for the Board of Elections. I'd like to pick up Judge Pillard with a question that you asked of my colleague about this point of comparison idea. And they have pointed to, as my friend acknowledged, a temporal comparison before and after. Now, the cases in which vote dilution has been recognized as a cognizable injury for Article 3 purposes involve situations where there is a comparison in geographic space or comparison between groups within the same election. They do not recognize this idea of a comparison across time. Part of the reason for that, and this, Judge Randolph, goes to the point you made. You brought up Michelle. My friend didn't acknowledge Michelle, but I think that case is quite distinguishable because there you have a derivative injury tied directly to a fixed legislative body with a set number of members at 435 by law. So there's a much easier path to finding a particularized injury to each individual voter and each individual congressperson. Whereas when you're dealing with a changing, ever-changing, diffuse general electorate, the point of comparison itself is essentially a moving target. There's no way to determine whose aggregate share of voting power, or as my friend put it, the aggregate share of the electorate any group might be experiencing. And so in that sense, along with the point that my friend acknowledges that every vote is still getting equal weight, this would be a quite anomalous theory of vote dilution when every vote is getting equal weight. And the concept of vote dilution is, by definition, unequal weighing of votes.
But Mr. Lee, go ahead.
I was just going to say, was there any, after testing, the results of the election, that non-citizen votes actually affected the outcome of the election?
I know how many, the board has kept track of how many non-citizens voted last election. I believe it was 480.
Do you have an updated registration number?
I believe it's 900, and I actually do have the numbers here. 900 and 480 voted. 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 900 980 citizens as of January, non-citizens as of January 2025 are
How
registered.
many of them were illegal aliens?
I don't know the number on that, Judge Randolph, and the reason I don't is because the council made a reasonable judgment that it would be unnecessary for purposes of the district's goal with this law, which was to expand access to democracy at the local level, to make distinctions based on federal immigration status. It's also considerably easier for the board to administer when they don't have to sort through all the different types of federal immigration statuses. And so, and under rational basis review, those are entirely proper judgments for the council to make. But yeah, so I don't know the answer to that. But I would acknowledge as well that my friends are bringing a facial
You
challenge.
don't know it. Does anybody in the district Board of Elections know it?
I don't know, Your Honor. I apologize that I don't. But part of that is because the law by its terms is not drawing distinctions among non-citizens based on their federal immigration status. And my friends are bringing a facial challenge to the statute. So they have to show it's unconstitutional in all of its applications, not just as to potentially illegal immigrants, but as to people who are lawful permanent residents, people with lawful visas. They haven't made that any sort of showing like that on any of their claims on the merits.
You pointed out that the plaintiffs allege that they're registered, but they don't allege that they have or intend to vote. I guess the question for you is, why is it necessary that they intend to vote to support their standing on a vote dilution theory? Can we infer that? And is the number of protesting non-voters that are registered, something that gives enough weight to their votes?
Well, notably, my friends have not argued that you should infer an intent to vote. What they've attempted to do is submit additional affidavits attached to their reply brief and drop a footnote in the reply brief asserting new theories or new allegations about intent.
They claimed that their vote was diluted. Now, that doesn't imply or suggest that absolutely states they vote. I mean, how can you have a vote that's diluted or evaporates without voting? I mean, it necessarily follows from the allegations in the complaint, it seems to me. But they've made a sufficient allegation of voting.
I think it has to be more than just an allegation of intent or even an implicit. It has to be a concrete plan, as Lujan teaches. It's not enough to just say, I intend to vote at some point in the future, even if they had said that. I think it had to be something a bit more, maybe a specific election, but.
Like what? Give me an example.
I think some of the allegations they put in their new affidavit, which are stated in the present tense as of January 25, they're not stated in terms of what they intended at the time they filed suit.
The allegations in the declarations are about voting in the past.
There are allegations, yes, but there are.
Some, before the statute was even passed.
Yes.
So I guess what you're saying is if you voted in the past, then we can infer that you're going to vote in the future.
No, Your Honor, there's more than the supplemental affidavits discuss not only past voting, but an intention to vote in the future. Now,
You're just saying it's too little too late, that's exactly what they should have argued. This is vote dilution theory, as Ms. Hall alleges in her declaration of January this year. I have voted for candidates for local offices in 20, and 22, and 24. I intend to vote in 26. And as Mr. Heller says, I voted in every presidential election since 1980, usually including voting for the local council members. And I plan to vote in the upcoming elections. And so your position is that's exactly what would have sufficed to raise their dilution argument, but it's too late because it wasn't in the complaint.
Yes, if they had alleged that in their complaint, they would have gotten past the imminence requirement. It would not have helped them when it comes to the particularization issue. It wouldn't have helped them with the generalized grievance problem, but it would at least make a showing or a plausible allegation of a certainly impending injury. Now, they
Where
didn't.
in your memorandum that you filed is the argument that they didn't sufficiently allege that they were voters? Where is it?
I'm sorry?
Where in the memorandum that you filed?
In your briefs, have you argued that they didn't allege that they had and will vote?
In the arguments in our brief, I don't know the exact page span, but it's
I'm talking about in the district court.
in the district court. Oh, I'm sorry, I don't have the exact page span of what our brief it was. I know we raised the argument below because they responded to it. The district court didn't address it. I can try to find it now. I apologize. But the argument I know was raised.
Was there any allegation in the complaint about?
I'm just
intending-
trying, I'm sorry.
No, I was just going to say, was there any allegation in the complaint about intending to vote or how the vote was to be diluted?
There are allegations, there are legal conclusions about how the law would go about affecting the votes. There is no attempt at quantifying what the degree of vote dilution would be. There's essentially a legal assertion that the effect of the law would be to quote unquote dilute the weight of or dilute I should say the voting power of certain groups or the citizens generally.
So I think, I mean, in this court, I think it's the red brief at pages 22 to 23 talks about on 23, plaintiff's complaint is noticeably bereft of any allegation that they intend to vote or run for office in future elections. The complaint asserts nothing about plaintiff's intentions or plans to vote, doesn't even allege that they have ever voted in past district elections. And I think Judge Randolph was asking, did you raise that in
Yes,
district?
yes, JA 26. I have the site.
J26 is where you raised it in the.
Yes, that is correct. Complaint has no allegations about intending to run in future elections, and the bare minimum they need to intend to vote, according to the precedent of the 8th and 9th circuits, which have addressed similar issues.
And does that matter? I mean, if these are Republican voters and they feel like Republicans never win in the district, why am I going to bother to go line up somewhere? Is the existence of registered voters who decide for reasons of futility not to vote, is that enough to raise a dilution theory?
I'm not sure it would be, Your Honor, but I
I mean,
would.
what if you were in a packed district and you're just, or maybe it's the inverse, in a cracked district? I have no, if 100% of people who share my interest went out and voted, we would have zero chance. So I care and I want to bring a gerrymandering claim, but really I have to have done the futile thing
Well, here's why you.
and say I would do it in the future.
Here's why you might not need to do that. There's two different aspects, if you will, to a racial gerrymandering claim based on cracking. One is the potential dilution of your vote. Now, if you don't intend to vote in the future, you may not have an imminent injury as to that. But the other component of it is essentially a racial segregation claim.
Right, the stigma claim. But I mean, that's not true for like, if we look at Gill, political gerrymandering, partisan gerrymandering.
Mm-hmm. That is true, Your Honor. But I would say nothing really turns on anything like that in this case, because here there's not a claim of futility. But even if the court disagrees with us on this imminence issue, that's only one component of standing for them. And getting past that doesn't help them at all when it comes to the generalized grievance.
You argue that the power of plaintiffs' individual votes was not diminished in any way. Really? I mean, what about is it Michelle or Michael, our case, where it is about a change to the ability of territorial representatives to appear in the committee of the whole in the House. It's a before and after change. So in that respect, it's just like the change here. What the plaintiffs are challenging is a law that, relative to how it used to be, does dilute their votes.
The difference is when we say there's no effect to the change of their votes, what we're acknowledging is the fact that they admit that the weights of their individual votes are exactly the same as they always were.
No, they're not. Because if you're, I mean, just like with the representatives being one of 435 versus one of 440, the vote of the representative after the inclusion of additional representatives is marginally diluted. So too, you add non-citizen voters, and after you've done that, your vote is, relatively speaking, diluted.
In analyzing claims that involve expansions of the general electorate, what courts have looked to is the fact that it's different. There's a difference between the weight of your vote and your share of the electorate. Now, acknowledge there are cases where the line can be fuzzy, but there is still a line, and it's one that makes sense when you're dealing with expansions of a diffuse and ever-changing general electorate versus a change or adding of non-members to a fixed legislative body. But I do want to, if the court has any questions, I'm happy, we're comfortable with the merits. If the court believes that there is standing here, we set out in our briefs why we don't think that's the case.
You said that there are cases about the differentiate between expansions of a diffuse and ever-changing electorate versus those that, take a particular number and add a particular number. Which cases are you thinking?
Well,
of?
Michelle is really the only one that I have found that involves the same type of fact pattern. And it's a highly unusual fact pattern tied, I think, to the unique context of legislator standing, which has a long history. There's been a lot of water under the bridge since Michelle. But in cases involving expansions of the general electorate, I mean, we have this court's decision in Dowtry, and I do want to take that case up because I think my friend has missed part of it. He's right that part of it deals with concreteness and speculativeness. But there's a critical part, there's a third leg of the stool with Dowtry, which is particularization. And this is in the sentence in the decision leading up to footnote 27, where the court says, these plaintiffs don't have standing, in part because they haven't shown that their votes are disfavored vis-a-vis those of some other group. And it borrows that vis-a-vis language from Baker versus Carr, which is referring to unequal weighing of votes in the same election where you have a fixed geographic location, malapportioned districts, to draw this comparison.
Would a voter have standing if, because of redistricting, they were placed in a district that had 10 times more people than the one that they were in? Would they have standing then?
Not if their proportion of representation corresponding to that district remains, if there's still a one person, one vote breakdown between the districts, I don't think they would have standing because there hasn't been a dilution of their vote.
Are you familiar with Westbury versus Sanders?
I'm only passingly familiar with that case, Your Honor. It hasn't been discussed in the briefing, so
I know.
I believe it involves congressional redistricting.
Held that because their vote would be diluted by being placed in another district that was more populous, that they had an injury that was sufficient for standing.
Well, taking that to another level, if you had more non-citizens in the district than citizens, and then we go with your logic about the votes are still counting the same in terms of the same weight, would then that be a different scenario?
So I want to take I apologize, Your Honor, for not knowing about Westbury. I will take Your Honor's word for it that the standing was found there. I do think
You
that
don't have to take my word for it. If you take a look at Michelle interpreted Westbury exactly the way that I put it.
okay, well,
Go ahead and answer the question.
Yeah, I understand, Your Honor. I think I may not be understanding the hypothetical of the facts of Westbury, but if you're taking one person from a roughly equally apportioned district and putting them in another district that just simply has more people, is how I understood the hypothetical. I'm not quite sure that, at least at the state level, that would be, if that's how.
This is from Michelle. The Supreme Court has repeatedly held that voters standing to challenge practices that are claimed to dilute their vote, such as being placed in a voting district that is significantly more populous than others. See Westbury. Is that
Right.
wrong?
No, Your Honor, it's not wrong. But what it's referring to something else. It's referring to a comparison between two different districts where they have different levels. They have the same level of representation, but different numbers of voters. And that's what creates the unequal weighing of votes, because the person in the less populated district, their vote has 5 or 6 or 10 times the power of the people in the malapportioned district. So that's an entirely different situation, because here the votes are weighing equally. But to pick up Judge Childs with your hypothetical, in that scenario, I still don't think there would be a vote dilution claim of injury on standing. There may be a different theory of standing, or there may be a different party that could bring a suit. There may be a candidate that could bring a suit. There may be a political party that could bring a suit based on either an organizational theory of diversion of resources, or a candidate could bring a standing claim potentially on a competitive injury. But for purposes of vote dilution, if the votes are being counted equally, the governing law suggests that there is no Article 3 injury in that context.
So you're still hanging on that there's a generalized injury here. But you also, in response to Judge Randolph's question earlier, when we were talking about the 980 voters that you can't kind of segregate out, based on who's non-citizens versus citizens, there's data points there to let us know that if there is some other type of injury.
I think that's right, but I think that's just a limitation on the facts of this case. If I'm understanding your hypothetical correctly, in the other situation, there just may be other types of claims that could be brought. But the fact that we don't know, I think, is further evidence that we don't know there's an injury that's been alleged.
Okay, so for right now, as to standing, you're hanging that there's no allegation in the complaint about the intending to vote or how the vote is diluted, or any allegations about running in future elections, therefore generalized grievance of standing.
I might just amend that somewhat.
Okay.
The lack of an intent to vote in the future and the lack of an allegation about running or concrete plans to run goes to imminence. That's an independent basis. They haven't alleged an imminent injury, but the injury they've alleged, even if it is imminent, is a generalized grievance that is not particularized to them because it's shared, as they admit, by every citizen in the district or by every citizen voter in the district.
Okay, and then on the citizen self-government, help me out there, because that term is not utilized a lot through the cases. And so is that forfeited also because not raised before the district court specifically?
Our position is that that theory of standing, that argument as a theory of standing, has been forfeited because it's not, it was not argued below as a theory of standing. Now, we acknowledge they alleged a cause of action with that idea. I understood my friend to concede that the citizen self-government theory of standing is essentially equivalent with their vote dilution theory. If that's the case, then it's properly before the court and there's no difference between the theories of standing. They are the ones that on appeal that kind of reframed it. Either way, though, it still is a generalized grievance for the reasons set out in our brief and as I've explained. On the candidate standing, though.
But you do consider there to be such a claim?
No, on the merits, no, I'm sorry.
Okay.
I'm sorry, I misunderstood the question. No, they are asserting a right, but in order to trigger strict scrutiny, that right, they have to show it is deeply rooted in history and tradition. Here, they have marshaled no historical evidence to support the idea that citizens since the founding have had this unenumerated fundamental right to exclude non-citizens from participation in local elections. They acknowledge the history cuts against them, and they simply say that they try to flip the burden back onto the district or the Board of Elections to show that the history supports non-citizen voting, but the burden is on them under Glucksberg to show that this right is deeply rooted in history and tradition. The burden is not on us to disprove that point. The fact that they acknowledge that the history is at best unclear, we would submit it's quite clear, but their theory is it's unclear. That's essentially an admission that they can't prevail on the merits, because Glucksberg, I think if you take it seriously, and the courts reaffirmed it in Munoz most recently, historical equivalence, it means that plaintiffs lose in a fundamental rights case. I don't think you can establish a deeply rooted right without a robust historical record supporting the claim that you're bringing. And so
you're, to go back a little bit in your argument, you're saying that the plaintiffs have waived certain arguments with respect to standing if they didn't raise it in the district court, right? You have strong support in this circuit for that proposition, but I've never understood the rationale behind it. If you didn't raise any objection to standing in the district court, have you waived it?
no jurisdictional objections.
Right. So the court has an obligation to decide cases only when it has jurisdiction, but there's a corollary, and that is the court has to take jurisdiction when it has it. And so I don't know why only the party opposing jurisdiction cannot waive any argument, but the party asserting jurisdiction can. It seems to me not to make much sense.
I respectfully disagree, Your Honor. I think it does make sense in this respect. I think it's rooted in the presumption that federal courts presumptively lack jurisdiction, and that the burden is on the party asserting or invoking the court's jurisdiction to affirmatively show it does exist. And the court should only exercise jurisdiction when necessary. And so if there's an argument in favor of jurisdiction and the party with the burden to invoke and show that affirmatively a jurisdiction exists, if they don't make that argument, I think it's a fair matter of procedure. And
If they make the argument in the district court and you're the defense counsel and you don't respond, have you waived? Have you waived any objection to jurisdiction? The answer is no.
right, but I think that's
Your argument, if somebody raises it in the district court, if you don't respond, you've waived the response. It doesn't wash. It doesn't wash in exactly the situation I'm talking about.
I realize there's an asymmetry, but I do think the asymmetry is rooted in the asymmetry of Article 3 itself, which
I
is
think
that
I'm wasting the court's time because
On the merits,
it's an uphill battle. Yeah.
why is it administratively easier for the board to have a voter registration system that doesn't take into account whether someone is a lawful, is a lawful documented versus an undocumented?
it is administratively easier because it is often quite difficult to sort through different types of and different statuses of federal immigration law. And if someone is coming in and they have, if the board is not necessarily equipped to be able to decipher out immigration fraud on the spot when it's registering people.
Is there not such a thing as like a green card?
I'm sure there is, but there are also fraudulent immigration documents that the board is not.
Fraudulent, IDs for citizen voting as well. And so one could have some kind of requirement that you have, what is the ID now? The one, whatever,
Yeah.
the real ID, or I don't know that. And I guess another way of putting it, is it rational
Well,
to allow undocumented people who are not present legally, vote?
all of those arguments, I think, would be persuasive if this were a heightened standard of review. And even under rational basis review, I don't think there are, but my friends haven't made them. They have forfeited entirely any argument that this law does not pass rational basis review by not arguing it.
Convicted felons can vote in DC, can't they?
They were re-enfranchised in 2019, yes, Your Honor.
2019, was it?
That's my understanding, yes.
That is people who are serving a prison term, or people who have served the term?
I believe it's people who have served. And who have
So
been-
they're people who are presumptively back as full members of society with their civil rights having been restored.
That is my understanding, although as I stated before, I'm not 100% sure about that, but I assume that that's correct. But to go back to what Your Honor raised fair points. If this were a situation where we had the burden to show it was rational by some colloquial measure, I think that would be, those would be arguments we would have to grapple with. But no one has raised them in this case, and the burden is on plaintiffs to show not just that it's irrational, but to negate every conceivable justification for the law, even at the pleading stage.
Does the fact that the act was passed for the purpose of enfranchising non-citizens make it subject to heightened scrutiny because it has the purpose of discriminating against citizens or American nationals by diluting their vote?
Not at all, Your Honor.
Why not?
There is no plausible inference of discriminatory purpose simply by enfranchising felons. And the reason for that is that the law, first of all, they have disclaimed reliance on legislative intent in their complaint at JA 13. They say legislative intent is not necessary because they think this is facially discriminatory. They're wrong about that. I think as the colloquy you had with my colleague shows, the law is facially neutral, but they've disclaimed any argument about that. They point to no well-pleaded facts in their complaint on this point. But the more fundamental legal point for why their claim fails is that the courts do not impute a discriminatory, invidious intent to the legislature simply because a law has an effect on certain members of the population, even when it might appear to be inevitable, particularly in a case like this where you have non-discriminatory rationales for the law. So if you take a case like Feeney, for example, You have a situation where there was a veterans preference hiring, right? And everyone acknowledged it had an inevitable disadvantage for women because of historical gender disparities in the military. And nevertheless, the Supreme Court recognized that, well, it does have this unfortunate effect, but we're not going to infer discriminatory intent because this is a legitimate law. It has other legitimate purposes. And so we're not going to draw this inference of discriminatory purpose simply because of its effect. Arlington Heights lays out a number of factors that go into the showing of discriminatory intent. My friends have not taken up any of them, particularly when you view this in light of the presumption of legislative good faith. There's really no basis to infer that there was animus towards citizens. To provide a few examples, Judge Randolph brought up the fact that felons were reenfranchised. I don't think anyone would infer from that discriminatory animus against law-abiding persons. If the district were to lower the voting age, I don't think anyone would infer that there was animus towards the
Once you
elderly.
register to vote, do you automatically become not eligible, but required to serve on juries?
You do not, Your Honor. My understanding is that the statute governing jury service still requires citizenship.
Still have to be a citizen to serve on a jury.
That is my understanding. Yes, Your Honor.
If we were to reach the merits of the Equal Protection Clause claim, does your position that the act removes a voting classification mean that plaintiffs have failed to state any equal protection claim, or does it mean that the act is subject to rational basis review?
It's subject to rational basis review.
And why, if there's no classification? Is it subject to rational basis review under the Due Process Clause, or is it subject, where does the Equal Protection Clause even have bite?
Well, I can only follow the doctrine of the court on this point. Conceptually, I'm not quite sure why you would go to rational basis review. It is a bit of a formality in many cases. I think it derives from the equal protection component of the Due Process Clause itself. I think but when the statute is facially neutral, I'm not aware of any court simply ending the analysis there. There's usually an analysis of rational basis, maybe as a backstop just to ensure that there is nothing wholly irrational in the law. It could be in certain as-applied claims. There could be an irrational application of the law to a particular person, even though it's facially neutral. Now, we have nothing like that here. But I think that's why a court might proceed to the rational basis.
And if we were in rational basis territory, do we apply the standard test and ask whether the law is rationally related to a legitimate governmental interest, or the somewhat modified version that courts looking at non-resident vote enfranchisement cases use, looking at certain factors to determine is the newly enfranchised group, do they have a substantial interest in the election, or is that just an application of rational basis?
I think
It seems to have a little more bite.
Yeah, 2 points. I think the outcome in this case is the same either way. I don't think the court needs to worry about that, but I see Your Honor's point that I don't know that it has more bite, this rationality when it comes to looking to the interest of those who have been enfranchised. I think it could just be a particular subset of the idea of rational basis review. Certainly, if you're enfranchising people with no legitimate interest in a jurisdiction, then it could very well be it's irrational. And my friend acknowledged the Brown case from the Eastern District of Tennessee involved that type of fact pattern. Now, that was entirely different in this case. It involved non-residents, fragmentation of voting, a thinly veiled effort to perpetuate decades of racial discrimination. Here, every person gets a single vote. Only residents, and this is important, only residents with fixed residency in the district who have disclaimed the right to vote in any other country have the right to vote in the district under this new law. So there are still limitations on which non-citizens qualify. And
All right.
thank you.
No more questions, I think.
Thank you. We would ask the court to affirm.
Okay. Now, did Mr. Hayek reserve any time? All right, we took you over. We gave you more time than that on the primary argument, but we'll give you the 2 minutes for rebuttal. If you want it, you don't have to take it.
Yes, Your Honor. We did state below that we had standing because our the plaintiff's right to citizen self-government was violated, and the violation of a constitutional right is an injury. And if you look
I thought
at,
you said that for purposes of standing.
yes,
that
for
is-
standing, we said that below,
That was the same vote dilution harm.
that it was We did allege though that separately in below that we had standing because our rights were violated. The right to citizen self-government was violated. We also said the right to citizen self-government implies the right to vote in an election in which only citizens vote. And that's on at pages 16 and 64 through 68. And we cite those pages in our brief. Defendant never responded to this argument. So if anybody forfeited it, it was defended. And the court, I think, passed on it by treating it all as vote dilution. And we previously discussed that, Your Honor. This is also not a general grievance. It's important to point out because not all DC voters are injured by this law. Only citizen DC voters are injured by this law. Non-citizen voters have been benefited by the alien voting law.
What about I mean, I found it striking that this is a case about vote dilution and there's nothing in the complaint saying that these are people who ever voted or ever intended to vote. That's really problematic. And I wonder why, once that was brought to your attention, why there wasn't an effort to amend the complaint in the district court.
If somebody goes to the trouble of suing, or if someone's public spirited enough to go to the trouble of suing over their voting rights, they're either going to go to the trouble. It can be presumed that they're either going to go to the trouble of voting or that it would be futile. It's very.
People have all kinds of programmatic interests that don't support standing to sue. I mean, that's a really central part of our inquiry. You could imagine.
It also follows from a claim of vote dilution, Your Honor, that you intend to vote. If you're claiming that your vote's going to be diluted. And also there's a statute that allows defective jurisdictional allegations to be amended in the trial or appellate courts upon terms. Which is Congress's way of saying that it doesn't.
What are you referring to? I don't recall that being cited.
Yes, we cited in the statements.
In the
statements in this court, Your Honor.
The statements?
The declarations of plaintiffs, Your Honor.
The declarations attached to the reply brief?
Yes, Your Honor. And I think that's Congress's way of saying that it's not right that defendants can't waive standing, but plaintiffs can.
Any other questions? All right.
The
case is submitted.
Thank you, Your Honor.
And
Case number 22-1318. Michael Muir petitioner versus United States Department of Homeland Security and Transportation Security Administration. Mr. Weaver, amicus curiae for the petitioner, Mr. Muir for the appellant, Mr. Waldman for the respondent.
Mr. Weaver, you may proceed when you're ready.
Judge Pillard, Judge Childs, Judge Randolph, and may it please the court. Will Weaver, amicus arguing in favor of petitioner. I'd like to reserve 2 minutes for rebuttal. TSA's final rule adopting AIT and the standard operating procedures requiring the AIT plus pat-down regime at airport security checkpoints failed to address a significant aspect of the problem before the agency. that for a certain category of individuals, those with internal disabilities or hidden medical conditions that are hidden from view, the AIT plus pat-down procedures prevent them from reliably and safely completing TSA screening to access commercial air travel in the United States. The standard operating procedures that require AIT plus a pat-down prevented petitioner Michael Muir from accessing his flight in December 2022. And the TSA's application of those procedures to Mr. Muir were both arbitrary and capricious and violated the Rehabilitation Act. TSA's frequent use of alternative screening procedures, namely walk-through metal detectors, shows both why the application of the standard operating procedures to Mr. Muir was arbitrary, and also why providing Mr. Muir an accommodation similar to walk-through metal detectors would not constitute an undue burden for the government under the Rehabilitation Act.
For the first part on the fail to address a specific aspect, did you forfeit the statutory challenge with respect to the AIT and the ATR argument?
Judge Childs, amicus did not address the statutory argument in its briefs.
But Mr. Muir did.
That's correct, Judge Pillar.
Why doesn't the 60-day deadline in 49 USC 46110A bar Mr. Muir's claims are brought far after the order at issue here, which I take it to be the standard operating procedures?
Judge Pillar, that's right. And I'd say a few things about that. The first is that the standard operating procedures are non-public. So Mr. Muir's petition was brought within 60 days of the application of the standard operating procedures to him on December 1st, 2022. The other thing I would say, this court has held that the 60-day time period is not jurisdictional in the Bonacci case. And that isn't an argument that the government has pressed that his claim is time barred. And I would say that's particularly the case with respect to the aspect of his challenge that is to the standard operating procedures. There's a fundamental mismatch between the security rationale that the government offers to justify denying AIT alternatives to individuals who have internal disabilities or medical conditions that are hidden from view, and the numerous other circumstances in which it does allow for AIT exceptions. And that includes travelers who are traveling with small children, passengers who are traveling with pets, passengers who are traveling with service animals, passengers with pre-check, passengers who are traveling in wheelchairs, and all passengers that are flying out of the 15% of airports in the United States that are not equipped with AIT.
In all those situations, I mean, what the government argues is it's really straightforward for a TSA operative to see if someone's with small children, a service animal, a pet, in a wheelchair, and in the airports where they don't have the AIT, there's no discernment needed as between people who would be eligible for the metal detector or would go through AIT. So I mean, one of the main things they say, which is, you know, part of the challenge for Mr. Muir is that, you know, there are millions of people going through these checkpoints every day, and they can readily administer sorting that is based on easily apparent characteristics.
Judge Pillard, with respect to the administrability question, amicus would point to the government is correct that in some of these circumstances, there is a sort of easy visual identifier. But amicus would point to, for example, for service animals and pets, there are forms that can be filled out under penalty of perjury that someone who wants to travel with a service animal or someone who had an internal disability or medical condition could fill out, again, under penalty of perjury, submit to the TSA, and they could be issued some sort of documentation that would allow them to immediately be identified as someone that needed to go through a walk-through metal detector. And amicus would submit that that would not constitute some kind of far-reaching burden on the government as the government suggests in its briefs.
You said that's also for people with disabilities?
Yes, Judge Pillard, that was correct.
Fill out the form, and then they can go through a different, like if you have metal implants then you fill out the form and you go through AIT?
Judge Pillar, I'm not sure if the form I'm referring to here is the one that applies for if you were traveling with animals. I'm not sure the precise.
I thought you said animals and something else, but.
And apologies, I mentioned both. I was saying the same type of regime that sort of applies if you're traveling with animals could apply in a similar circumstance. You could have a one pager that the traveler fills out, and then the TSA, looks at that and issues some kind of documentation that they could readily identify.
Just as a matter of information, I know this may be in your brief, but there's a lot of subcategories. If you're traveling with an animal and you don't go through AIT because it won't work keeping you together with the animal and going through AIT, you go through a metal detector.
That's my understanding, Judge Pillar.
And you're subject to routine pat down as well, or no?
It's Amicus's understanding that you can be subject to a pat down at any point, but certainly if you go through a metal detector as well as going through AIT. Petitioner's particular problem in this case, and what gives rise to the challenge, is that for him,
I understand that. I guess maybe these are just questions for the government, because it's a little bit unclear when metal detector is routinely accompanied by pat down and when it might not be. But I'll ask the government about that.
I was going to say too, kind of in telling this story, it seems like that we're left without certain of the details that are plain to, that appear about what happened. Once plaintiff goes to the TSA gate, you give your boarding pass, you give your ID, and then we just kind of don't know what's happened after that with respect to, did he go through the AIT machine? Does the machine alert? Does the officer attempt to pat down? Does he alert every time that he goes through machines and things like that, to kind of give us some sense of what does he really need, or is it better for him to have just fill out a TSA pre-check form so that he doesn't have to go through this particular machine?
Yes, Judge Childs. And so I would say that within the record and with the declaration that's attached to the briefs, Amicus's take on that is that there are, for Mr. Muir, the potential that he ends up with an extremely painful pat down is substantially increased going through AIT. And so for purposes of standing, that meets the New Jersey USCA. But in terms of there's a way to read the declarations that there seems to be some sort of, factual question there. But with respect to petitioner's claims, it's Amicus's position that it doesn't matter precisely at what point on December 1st, 2022, he was prevented from going through the machine, whether he stepped into the machine or did not. It isn't really relevant to the question of whether he has standing to challenge the standard operating procedures and bring his claims. And I would also just point out that the evidence that the government put in on that, the Sebastian Declaration, is not conclusive, on the question either. So there is perhaps a factual dispute.
Well, there's two machines that you go through. I mean, if you have TSA pre-check, you go through a certain machine. And then if you don't have TSA pre-check, you go through the other machine that requires you to put your hands up, and then there's a scan around you. And so it kind of matters of whether or not he alerts, with respect to going through one or either of the machines.
Judge Schultz, I'm not sure. I want to make sure I'm addressing your question. My understanding is that because the AIT falsely identifies petitioner's hernia as a threat object, that's sort of what causes the substantial increase in likelihood that he's going to have to endure the pat down. And so he needs a circumstance where he can arrive and know that he is going through a metal detector and not the AIT machine.
So what is the accommodation or range of potential accommodations that he's raising? I know he wants to not go through AIT, instead go through a metal detector. And the reason I was asking about whether people who are routed as a routine matter through metal detectors, not because of the airport only has that, but because, for example, if they're with a service animal or they're over 75 or what have you, whether those people are routinely patted down, because if they are, that's not an accommodation at all. So what is the accommodation that you understand Mr. Muir to be asking for?
The accommodation from Amicus's perspective is access to the walk-through metal detector, because even though in some circumstances there may still be a pat down, the chances of that occurring is substantially decreased because his hernia would not register the walk-through metal detector in the same way that it registers as a threat object on the AIT
And
machine.
is that the same one that the TSA people, the pre-check people go through?
That's my understanding, Judge Childs. I'm not sure that it.
Fill out the TSA pre-check prerequisites to get that type of card.
Well, Judge Childs, I would say two things about that. With respect to the Rehabilitation Act claim, I do think the fact that TSA PreCheck does cost money, right? There's a cost associated with it. And it's also, the requirements of PreCheck are not designed for individuals with disabilities. There are requirements and background checks and other things that just aren't germane to that issue.
But isn't there an ability to indicate ahead of time whether there's a card or some kind of medical documentation so that you kind of have that confidentiality or sensitization that you would go through to an officer ahead of time that you could fill out?
I think there is. There's the card and there is a hotline. And what I would say about that is however that operates here, and there's not a lot in the record about, whether that was at issue for petitioner, but the TSA is a party to this case. I think that they could have said in the briefs, if Mr. Muir were to dial that hotline or fill out the card, then he would have access to a walk-through metal detector. And from Amicus's perspective, because the government hasn't made that argument or assertion, that whatever, the regime that exists with the hotline and the card isn't sufficient to ensure that Mr. Muir can go through the walk-through metal detector as opposed to.
Speaking of not making an argument, you were appointed by the court. You don't represent the petitioner, is that right?
That's correct, Judge Randolph.
How can it be then that you can raise arguments that the petitioner hasn't made? You don't have any standing whatsoever to do that. Well, the business about comments and the failure of the agency to respond to comments during the rulemaking, Mr. Muir doesn't raise that.
Well, Judge Randolph, I would say in the petition, he does raise a challenge to the rule, and I think fairly read to the standard operating procedures that implement it. And
he doesn't raise the argument that I just said.
He does not discuss in his petition.
So on what basis should we even consider that?
Well, Judge Randolph, he does invoke section 46110, and the court's review under that is under an arbitrary and capricious.
The 60-day rule we've held is not jurisdictional, but we've also held that the portion of sub D requiring an objection before the court will consider it, an objection before the agency is jurisdiction. And if there was no question about, or no objection along the lines of anything that you're arguing, then I don't see how you can possibly argue it.
Well, Judge Randolph, we do discuss that. Amicus discusses that in the briefs as well. So there are, and the court asked Amicus to address the question of Vaughn and Olmstead and how they interpret the statutory provision you're discussing. I think there's no, to me, it's very clear that the Vaughn holding is correct here, which is just to say that as long as comments were raised by someone during the rulemaking, and that's why in this case, Amicus was pointing to comments where, during the rulemaking before the TSA, there were commenters who raised issues that are, Amicus would say, in the same category and similar to Mr. Muir's, which is folks with internal disabilities or medical conditions that would present a problem for screening. So I would say two things to address the question about 46110D. The circumstances in the Olmstead case, which is the older case where the court did hold a party to require them to have made the same arguments before the agency, that case involved attorneys for, I believe it was a municipality, and the attorneys had been involved in the initial agency process and raised other arguments, failed to raise an argument that they then later raised. And so there they were held to the court said that in that case, it needed to have been the party that was later arguing the issue that also raised it before.
The provision that I'm talking about in the portion of D, sub D, they have to raise an objection before the agency and if you don't, then the court can't consider it, is common throughout administrative agencies. Common provision, and the Supreme Court has held that the government, even the government, can't waive that. There's a case called EEOC versus FLRA that the Supreme Court decided, and the government did not say, hey, you didn't object. The Supreme Court said, you can't waive that. It's for the protection of the courts and sufficiently like jurisdiction that we're not going to allow the government to waive, forfeit, waive, whatever you want to call it. So that's a pretty strong rule.
So I guess the question is, you do point to, or maybe it was Mr. Muir who points to comments on the final rule that raised question of hidden disability and other comments that raised questions, I think, about possibly hazardous pat down. But what's tricky and distinct about Mr. Muir's situation is the combination of those two things.
Mhm.
And I don't think that there's any comment that raises a situation really analogous to his, that presents the difficulty of accommodation that his case presents. Is that right?
Judge Pillard, amicus would agree at that level of specificity that is not raised in the comments. The other thing that I would say, though, with respect to the 46110D issue is a question, and it's an issue with respect to the aspect of the challenge that is to the final rule, but it's not with respect to the challenge to the standard operating procedures that implement this AIT plus pat down regime, which is sort of the core. I think the petition read fairly. That's the core of the challenge. The final rule doesn't lay out in detail all of the ways in which TSA is going to administer AIT. That happens in the standard operating procedure. That is a document that is not public, and it is one that was applied to the petitioner in December 2022, right before he raised this challenge. So the 46110D issue isn't an issue with respect to his challenge to the standard operating procedures.
Because those are not notice of comment rulemaking.
Right, and there would have been no opportunity to raise
Go back to a point that Judge Childs made, which is that if he had put up the $75 and got cleared through the pre-check, he would not be going. He would be going through a metal detector, wouldn't he?
I think in most cases, I think in almost all cases, that's
Why isn't that an
correct.
accommodation?
That would be an accommodation, but because under the Rehabilitation Act, because there is a charge for that, and because it is a program that isn't really germane to the issue of individuals.
No, there's a Supreme Court case that, for lack of a better description, held that you can't be too poor to declare bankruptcy. When you declare bankruptcy, you have to pay a court filing fee. And there was a claim that that was unconstitutional and discriminatory and so on and so forth. And do you know this case?
Not off the top of my head, Judge.
And so the Supreme Court upheld the filing fee. And there was a newspaper reported the case, and in the newspaper report, it said what happened after that is that the plaintiff in that case paid the filing fee.
You said that,
So
I'm sorry.
If I can find that case, and I will, I mean, doesn't that sort of undercut your argument? Well, this is terrible because he's got to pay $75 for 5 years of pre-check.
Well, Judge Randolph, I would say under the Rehabilitation Act, while amicus doesn't have a case that's specifically on all fours, I do think the American Council for the Blind case and the rationale laid out there discusses the idea that it can't be the case that just because there would be a way for an individual who otherwise had a Rehabilitation Act claim to obtain access if they were to spend a lot of money to do so, that can't be enough for the government to deny access under the Rehabilitation
What happened to
Act.
that case on remand?
I'm sorry?
What happened to that case on remand?
I believe that it did not go in favor of the plaintiffs in that case.
Just to get a clearer sense of what is the accommodation that's being sought, you said it's to go through a metal detector, presumably without any supplemental requirement that you be routinely subject to a pat down as part of going through the metal.
That's right, Judge Pillar.
So taking the chance that you might,
Mhm.
if something alerted, but I gather Mr. Muir thinks, I'm going to take all of my metal buckles and watches off, so I'm not going to alert it, and that's going to be fine.
I would say Judge Pillar, at the very least, I do think, amicus could imagine other accommodations that went further than that perhaps for individuals that have this problem also gave them an accommodation for those, fewer circumstances where they went through a walk-through metal detector and then also needed to be patted down.
It's just really difficult to assess and to ask the government to assess, is this presenting an undue burden if we don't know what the it is? And I know that what's being required is challenged as under the Rehabilitation Act, but to know what would be an acceptable regime, especially from those that already exist, would be helpful. For example, you objected to the money, had some back and forth with Judge Randolph about that. What if the government said, okay, we're going to waive the fee, or if we held that's de minimis, $15 a year for 5 years, then would the treatment under pre-check, which sounds like it's exactly what Mr. Muir wants, which is get routed to the metal detector as an ordinary thing without deluxe pat-down supplement, is that an accommodation that would be sufficient? And we can ask Mr. Muir if this is not something, I know you're
Just for that-
not counsel, so.
Judge Pillar, I was going to say that's part of the challenge is that question of I don't want to speak for the petitioner on what would be sufficient, but from amicus perspective, and I think what we laid out in the briefs is the idea that what I hesitate to agree with there is I'm not entirely sure that even with the fee waived, TSA pre-check would lead to that outcome. And part of that is just, I don't actually know if TSA pre-check in all cases routes you through the metal detector. So I don't want to speak that.
We shouldn't be asking you. I can ask Mr. Muir, and I can ask the nature of the pre-check of the government. Done? All right.
Thank you.
Thank you. And we will hear now from the Muir. Morning.
Good morning. Thank you, Judge Childs, Judge Pillar, Judge Randolph. May it please the court. I'm here today to discuss the 3 orders that were made by the special panel in this case and how they relate to the advanced technology and the ultimate relief that my petition seeks. First was the December 7th, 2023 order directing parties to address 49 U.S. Code 46110D. And I think to your question earlier, Judge Childs, I have satisfied the jurisdictional requirement because contrary to respondents' assertion at their answering brief, page 41, previous objections raised during the notice and on the proposed rulemaking allow my statutory challenge because my declaration at Joint Appendix 112 mirrors previous comments by other commenters at Joint Appendix 55, 60, 160, and 163. And so, and then also those are listed at my brief at page 2. And if general objections about disabilities satisfy section 46110D, then I would say general objections about the ATR software also satisfy that requirement. And that's at page Joint Appendix 160 that the ATR software is raised. Second would be the June 10th, 2024 order allowing me to raise OMB memorandum M-24-10 as it relates to the ultimate relief my petition seeks. And I would say there that on December 16th, 2024, the respondents identified the ATR software as artificial intelligence. And that's at Joint Appendix 312. And I believe they identified as DHS 131, and that's at row 152 of the spreadsheet. So the court can be confident that this is artificial intelligence that they're dealing with. And then third would be an order related to a motion that is still pending, and that's the motion to supplement the administrative record. The order on July 10th, 2023 referred that motion to this panel. And I would say that the joint appendix from page 206 to 275 should be considered because the advanced imaging technology manufacturer Leidos was just granted won a $2.6 billion DHS contract on January 2nd of this year for integrated logistics support for the TSA security detection systems equipment. So I believe that their attorneys' comments on the real world functioning of the equipment apply here.
Can I ask you, Mr. Muir, about some of the questions that perhaps inappropriately I was asking amicus about what is the accommodation that you're seeking? It's easier for us to assess the claims of TSA, what would require a fundamental alteration of their program if we have a sense of how what you're seeking lines up with anything that's currently offered. Why would PreCheck not give you exactly what you're seeking?
So PreCheck cannot give me what I'm seeking because I am subject to being put through the advanced imaging technology machine at any time at the TSA's discretion. So PreCheck in no way protects me from the exact situation that I'm trying to get a relief from. And what I would,
getting a letter from your doc?
so that is not sufficient for TSA, Judge Randolph.
I asked whether you tried it.
I didn't because TSA does not have to accept any reason at all whatsoever, including a disability-caused medical emergency, for me refusing a pat-down, Your Honor. And
to get an accommodation, they have to know your condition. Isn't that right?
I don't know, Your Honor, because there is no process to get an accommodation from TSA.
Well, at the gate, at least, when you're going through the metal detector or the other device or pat-down or whatever, I mean, there's a face-to-face contact.
And it's that exact face-to-face contact that I'm here, Your Honor. On August 12th, 2018, my condition was the reason for a false threat alarm in my right groin. And since I had already been through it once before on the 9th, I elected to go into a private room. There in the private room, I was desperate to not be touched, Your Honor. And I offered to actually, in the spirit, because I'd read, I think in Oklahoma TSA case, they said that it's nothing different than a locker room, Your Honor. And so there was two males in there, and I offered to lower my pants so that they could see that I didn't have a threat object. And I told them what had happened a few days earlier. I was desperate, and they refused. Face-to-face does nothing, Your Honor. I have no guarantees whatsoever that they'll listen to me or take a doctor's note or anything like that. There is nothing.
Is that incident the subject of any of your prior litigation?
Yes, it was, Your Honor.
Yeah. And what happened? The court, Seventh Circuit ruled against you. I can't remember why.
I think it's because this court, Your Honor, is the only place where my challenge could be properly heard.
I think it was because you filed in the district court and they said you had to file in the Court of Appeals.
For a petition for review.
Right.
That's correct.
Yeah.
Did you ever receive any follow-up emails from the DHS Office of Civil Rights and Civil Liberties after it sent you the letter that you attached to your reply brief, the January 7, 2020 letter?
No follow-up.
Saying that it was recording your complaint. No follow-up.
No follow-up whatsoever. No.
And did you ever get a TSA follow-up on the email that you sent? And they said they were assigning your claim to an examiner for review. It was a November 2019, or is that the predicate to the?
That claim was denied.
Uh-huh. So just to circle back, the accommodation that you're seeking, I think it is the plaintiff's burden to identify the accommodation that you're seeking. What is that?
So I would say
range of accommodation.
Sure. First, with regard, and that's why I raised brought the statutory challenge, because I don't know if it's an accommodation. I would say that first, TSA is not entitled to analyze data regarding tissue beneath my skin.
I'm actually asking about the Rehabilitation Act claim. So I'm setting aside the statutory claim for now. Sorry, I wasn't clear about
Okay.
that. And assuming that you're having a disability that prevents you from participating in the program, which here is the TSA screening program. And then the question is, what's the accommodation you're seeking? Is it reasonable, or does it pose an undue burden on TSA, in which case they wouldn't be required to offer that accommodation? So assuming that you, just for purposes of the argument or my understanding of how your position plays out, if we set aside the statutory argument and we're just looking under the Rehabilitation Act, what would the accommodation that you're seeking, assuming that the AIT technology as they're using it is lawful, as they're using it in the general course?
I would say I don't want to be arrested for refusing a pat down at the site of my medical emergency. I don't want to be fined in the TSA court because there's no legitimate reason to refuse a pat down. And so if I'm in a situation where it's the pat down or another option, I'm going to take the other option because that happened before. I can't let anyone touch me like that again.
That you're wanting, the other option. Is
To
it metal detector or even AIT and a private room to do as you described, the locker room pants strap?
That's it. So what I asked for in November of 2019 was to have all threat alarms at my right groin resolved through visual inspection for the rest of my life. I do not want to be touched there. I cannot be touched there. And that was what I proposed in November of 2019.
And is that the only, or, I mean, as I read the briefing, there was some suggestion that a metal detector would be your preferred approach, but is that only because the AIT virtually invariably triggers a groin specific?
Exactly. It's the focused nature. Whereas I guess if I went through the metal detector and I had to be pat down, it'd be my whole body. And so then in that case, the alarm is not based solely on my disability. Right, it's there and only there. I mean, it's very clear. So I would say they shouldn't be allowed to use that information to raise an alarm in the first place. But if this court thinks that they're using it lawfully, then I would say this is why I'm here. It's really tough, and I understand like from the other side, but I can't be touched again like that. And if I refuse, then as there was like pretty troubling to see in the respondent's brief, they raised city and county of San Francisco, whereas like I could see a scenario where I'm very resistant to being touched and local law enforcement is called. And what I took from that case is that like they can shoot and kill me, and that's not unconstitutional because there's no clearly defined right against algorithmic discrimination of narrow artificial intelligence. There's clearly no defined right for that. This is an advanced technology case, and I think that the court should get it. Yes, Judge.
I just still want to be clear. So you really don't want to go through either scanner?
I mean, I understand that I have to. I have to be screened in order to
Okay, so
get on the other side of the sterile area. Yeah.
So which screener is that? The AIT?
Well, here's what it is. I'm happy to go through either one as long as they don't use my health information regarding human tissue beneath my skin as the predicate for raising a potential threat alarm at my right groin. And when I'm not symptomatic, I can go through the AIT. It's only because the software, artificial intelligence software, it doesn't know anything. It's contour, pattern, and shape, and it's algorithmic, and it flags it as an anomaly.
So I guess what I'm asking then is, for example, when Judge Randolph asked about the letter from the doctor that becomes very explicit, you hand that over to the TSA officer. You still go through the appropriate screening mechanism that you have this letter. The scanner alerts directly to that area, but you also had the letter. So the scanner matches up with the letter. Then you go to a room, allow the visual inspection, and then the three of those instances, letter, scanner, visual inspection, get you through. Is that sufficient?
I think you can ask the government, but I don't think
No,
it
but I'm
is.
asking you, we're still trying to
Oh,
get from you what you
yeah.
want as an accommodation.
Matches up with the scanner. I don't think that would fly with them. That would be great. That would be great for me. If it was that easy, Your Honor, then I'd go 3 hours early and I would leave enough time, and that would be great. Yeah.
Okay, but even on something like that, potentially that might be something that has to be developed through the trial court or an order or, something like that, because I don't know that this record gives us that. Because you don't have the doctor's letter. You have, certain information that you're telling us about, but that sounds very specific, and you're telling us sometimes it alerts, sometimes it doesn't, sometimes you're symptomatic, sometimes you're not.
That's correct. And it
Right.
only alerts when I'm symptomatic solely
Okay.
because I'm symptomatic.
Okay.
Otherwise, I could get right through like I did on June 6th and June 9th,
But you
2019.
also
Fly to come here? Were you able to fly to?
No, I had to drive.
Okay, but you also understand, when we're looking at the undue hardship burden, this whole screening process is what TSA would argue is most effective, least intrusive, in terms of it detecting metal and non-metal, without physical contact for any person who is going through that issue. That's the reason why they chose this particular methodology.
Yes, and I would say if they had followed the statutory language, and what I would say is what I really want is a final review of that potential threat or alarm anomaly flag by a human being. Because, as I point out in the briefs,
But are you asking a review of the final rule or asking for an accommodation for you?
for me, when that data is flagged, when my screening data is flagged by the algorithm, if it's at my right groin, I think the only way for the Rehabilitation Act to apply is to have a human being making the call on whether it's an anomaly or not, because software doesn't know what the Rehabilitation Act is, and it can't be trained in it. Only people can be.
So in the, just what, to wrap up my understanding of what the accommodations, range of accommodations are, that you would be okay with the metal detector, in part because in your view, you would take the risk that it will alarm on metal and that they will pat you where there might be metal, but that would not be the sensitive area of your hernia. And therefore that to you seems like a reasonable accommodation. Am I right?
I mean, those seem like good odds because it's completely human tissue and it's completely beneath the skin. Yes,
Okay.
Your Honor.
Good enough. Thank you. So we will hear now from Mr. Waldman. Thank you, Mr. Muir.
Thank you.
Good morning, Your Honors. My name is Joshua Waldman from the Department of Justice, representing the respondent TSA. TSA's AIT rule is not arbitrary and capricious. TSA expressly acknowledged and replied to comments from travelers with disabilities who objected to AIT or pat-downs, that the petitioner or those commenters didn't get the answer that they might have been hoping for. Does not make the rule arbitrary and capricious. does not mean that the agency failed to respond to those comments. TSA also reasonably explained why some passengers are not primarily screened by AIT. For example, because they are low-risk passengers who have gone through the pre-check procedures, or because they are categorically ineligible for AIT.
Who is in that latter category?
So for example, those would be people who could not stand or raise their arms in the required position for AIT. Those would also include people who had like a service animal or a service dog. It would also include people who have an oxygen concentrator that can't be removed, or people who had to be accompanied by another adult, for example, someone with dementia or autism who could not be separated from their companion.
And how, so those people go through metal detector?
Most of them would go through the metal detector, some of them would not. For example, if you're someone who can't stand because you're in a wheelchair, they're not going to direct you to the metal detector because the wheelchair would just set off the metal detector. So those people, as the rule said, people who can't stand in the required position would go through a pat down as opposed to the metal detector.
Also, another category, which you triggered. I had a friend, actually, who was a federal district judge in the South. He couldn't go through a metal detector because he had shrapnel from World War II.
Right. Someone like that, and it's similar to the Riskai case in the First Circuit.
Yeah.
If you opt into you can opt into AIT, for example, even if you were going to otherwise go through the metal detector. So if you had pre-check, you could just say, I'd prefer to go through AIT, and that would be fine. And it's not obviously a security concern because the AIT is better from a security perspective for all the reasons stated in the rule, which is that it detects both metallic and non-metallic threats, which is all what the technology is about and what Congress directed TSA to be sure to check for.
Some of the conditions that you just finished listing are not self-evident. A seeing eye dog, for example, you wouldn't necessarily know. Well, maybe you would because the person would be blind and that's why they did. But some of those other conditions are not self-evident. Is there some sort of a certificate that TSA issues containing the information that would entitle the person to skip the artificial intelligence screening?
Not the latter part of what you said. There's nothing that you can say that like certify a medical condition that gets you out of what would be the otherwise applicable security screening, but you can fill out a form, and there was some reference to this earlier, that just if you have a medical condition that you'd like the officers to be aware of, but you don't feel comfortable or for whatever reason you don't want to talk about that out loud, you can write it on the form and it's a recognized form and the person would understand it. For example.
So how does that work with somebody who can't lift their arms, let's say? And they don't want to say, do they fill that out? The person looks at it and they say, oh, you can go through the metal detector?
The officer does have discretion in that example to do that. Sometimes there's outward signs, but I do want to actually emphasize a point that you said, Judge Pillard, about it sort of being obvious to the person. And while that is a factor, there's really something antecedent and much more important, which is that someone who, for example, can't raise their arms, or someone with a service animal, the AIT won't function and it won't be able to get an image that can be analyzed by the software. And so it's not as if the person can go in and get scanned anyway. What would effectively happen is the machine would say, they can't do a scan, as opposed to Mr. Muir is not in that category, whether it's readily apparent or not, he can be scanned. That's really not disputed in the record.
I think we're partly asking what the different regimens are, as well as how a person becomes eligible. Like if you come up and you have a service animal, do you need to have a card? Do you need to have a letter? Do you need to have any communication, or do you just show up and they say, oh, and they put you in a line that goes through a metal detector?
Well,
or you not even go through a metal detector, you get a pat down?
No, you would go through the metal detector. And I believe with a service animal or a pet, you would get a swab of the hands as well with the explosive trace detection. The animal would get its own screening as well as any equipment. I'm sorry,
Does the individual get a full pat down?
not routinely,
Yeah.
no, in that situation.
Why not?
Why not?
I mean, if
Because
I'm coming, when you talk about
unless,
everybody needs to be screened, and my sense is that for non-metallic explosives, the metal detector isn't enough. So you go through and you do a hand swab for explosive traces, and you just do the metal detector, and that's enough.
right, yes, I believe, now, you have in the record, and I'm not going to discuss the details here because it's SSI, but you do have in the record all of the various procedures under the standard operating procedure, and there are nuances there that I can't sort of get into here, but you might want to read that record as well. But there are, the TSA obviously has to, in addition to having security concerns, manage the flow of the security checkpoint. And if they had to routinely pat down people who didn't alarm, I think that would seriously impede that part of its performance.
So if Mr. Muir, and if, like, I gather you can travel with a small pet, like
Yes,
not
pet-
a non-service animal?
Yes, TSA does not distinguish between a service animal and a pet, consistent with other non-discrimination rules, the government is not supposed to insist on certification that the animal is
So if
certified.
Mr. Muir would get a travel pet, that would resolve, it sounds like that would resolve his.
Sure, just the same as if he applied for pre-check. And
But
was
pre-check, is it right that you always go through a metal detector with pre-check, or do you go sometimes through AIT?
Well, TSA in its rulemaking did reserve the right in particular circumstances to direct everyone through AIT, whether you had pre-check or not, based on particular security circumstances. Or I could imagine a situation in which the metal detectors were all non-functioning, and so we sent everyone through AIT.
But if the
But
metal
as a
detectors are all
routine,
non-functioning, then the people with the pets and the people who can't raise their arms, they still need something.
they in those situations, perhaps, I don't know what they would do, particularly if like all the machines broke. I assume they would probably do more pat downs or try to direct people to other security lines. I honestly don't know that hypothetical, what would happen. But to answer your question, as a routine course, the people with pre-check would go through the metal detectors unless, as they can opt to go through AIT, or they can opt for a pat down if they prefer that too. But as a routine matter, they would go through the metal detector. And our point is, if that's what the petitioner is asking for, and even listening today, I'm still a little bit confused on what exactly that is. And there seems to be some disagreement or maybe not complete alignment between the petitioner and the amicus. But if the request is for going through the walkthrough metal detector, there is an existing program, pre-check, that the petitioner can apply for. And if approved, and millions of Americans have been approved, he would just get the option of primarily going through the walkthrough metal detector. Now, it is the case that just because you go through the metal detector doesn't mean that you're exempt from pat downs. There could be an alarm. You could be pulled out randomly, as anyone, pre-check or not, could be for a pat down. So we can't guarantee that that won't happen.
But that pat down is for either metal or random.
That's correct.
Okay.
Yes.
And I've been patted down many, many times. I mean, obviously, it's not in the factual record, but it's not typically in the groin area when you come through a metal detector and there's an alarm.
Well, I don't think that that's right. My understanding is that when you go through a walk-through metal detector, if it alarms, they don't know where on you the metal is, so they have to do everything, including like the full body. And in fact, that was the claim, that was the issue that was raised in the Sky case in the First Circuit, which is that petitioner had wanted a more targeted pat down in the First Circuit. Right, and the First Circuit said even that would not be, that would fundamentally alter TSA security screening, and that proposed accommodation was rejected by that court.
What about someone who can't lift their arms? They walk through the metal detector.
Right.
And this may be, I know that in the standard operating procedures march through some of this, but it wasn't entirely clear to me in some cases. If you go through the metal detector, first of all, how do they know you're someone who can't lift their arms? Do you have to say that
You have to say it. Often there are outward signs, like the person is showing you, you can see visually. I just think of like John McCain or Bob Dole, sort of somebody you can physically see, but it's not always the case. But the person would sort of communicate that they can't do that. And then the officer would then have discretion to say, okay, you can go through the walk-through metal detector.
Okay, you go through the walk-through metal detector, and then even if it doesn't alarm, does that person get a pat down?
No, my understanding is that person would not get a pat down if the metal detector did not alert. Unless, for example, they were pulled out for a random selection. And our point as far as the Rehabilitation Act is if that's what you want, then just you can apply for pre-check and you would get exactly that same treatment. So if that's the accommodation we're talking about, there's an existing way to do it. And our view is if that's available to the petitioner, there's no sound basis for the court to order some other kind of accommodation that would be more detrimental to TSA's security screening program when this existing mechanism is available. And again, that was the exact holding of the First Circuit in USCA, which said if the petitioner wanted what she wanted, she could just get pre-check and she did. And as that system expanded, she would get exactly the type of screening that she was looking for. And for that reason, they said, we're not going to require a different accommodation, which would be for TSA to create a system of medical documentation and verification so that they could present that at the airport. There's no reason to do that. And I think that's particularly so when we're talking about an individualized claim here for one person.
Speaking of the individualized, your briefing somewhat persuasively says, look, we should have had administrative proceeding below, but when you look at the documents, when you look at the regulation, when a person submits a complaint, I'm just missing the acronym, but the Civil Liberties CRCL is under an obligation to investigate, make findings of fact and conclusions of law, description of a remedy for each violation found, notice of right to appeal. None of that was done when Mr. Muir made a complaint to CRCL. And so why is there not a futility argument, or should we remand and say, can you actually do the thing that the regulation says you're supposed to do?
Let me address that in several parts. One that's specific and then the broader question. On the specific, I agree. And I reached out to CRCL through agency counsel. And the answer is that this was an error, that it should have been investigated at that point and it wasn't. I will say, just as it relates to this case, the complaint that was filed was not about the incident that is the subject of the petition for review in this case. It was about
the identical incident.
Yes. And it was on its face an untimely administrative claim that came, you have to file it within 180 days. It was filed more than a year after the incident. But all that aside, we are not making an affirmative argument here that you cannot reach the merits because of a failure to exhaust administrative remedies. We're not making that claim here. We only brought it up to make the point that I think this court is making here, which is that there's a lot of unknowns about the facts of this case, how often the petitioner has a situation in which AIT would alert. Is it sometimes, always, occasionally, frequently? What can be done about it, exactly what he wants. There could have been a range of options, and none of that was explored and presented on a record. We're just here on a petition for review, and we have very few concrete facts about that.
So given that, what are you suggesting?
Well, what we think the proper answer here is petitioner should just apply for pre-check if that's what he wants, and the court should not order any additional accommodation. He's entitled to get that if that's what he wants.
If we're unclear about whether that is satisfactory, it's much more intrusive background. Someone who can't raise their arms doesn't require that. So if there's a way for him to be in, I mean, it sounds like what you're saying, and to some extent what Mr. Muir is saying is like, the standard thing in a Rehabilitation Act situation, which is there should be some back and forth. What's possible, what's easy, what's not an undue burden, and what would work for you
Mhm.
among the non-burdensome options. And if we thought that there's not a categorical reason to dismiss or to grant this case, what would you suggest we do?
What I would suggest you do is you would say, on this record before this court, we do not see any basis to order an accommodation under the Rehabilitation Act when pre-check is available and appears, based on the record before us, to give him the relief that he wants. But if there's something beyond that that the petitioner wants now or in the future, he's free to file precisely that kind of claim, either directly with TSA or with CRCL, and there can be back and forth. And this court would expect TSA to do the investigation that CRCL erroneously did not do before. And I think you could decide the case on that basis.
But then he would have to go do a whole new case, or he'd have to go try to travel again, try to go by air, I mean, if we were to remand based on he wasn't required, given his past experience, to do the administrative thing, but it'd be a good idea to do it now.
I mean, I think it would be within your authority to say, go back to the agency and have that back and forth without him having to file something new. I mean, it's not like there's a filing fee for that. But I don't think that we have a preference between saying, go write a letter, Mr. Muir, versus agency, go back and talk about it. But
I thought you were saying deny this case and let him in the
I mean,
future file a new one. And
well,
that seems a little
well,
rich when the administrative process was apparently not fruitful in this very way.
Well,
in his past experience.
with respect to the claims under the APA statutory authority, I think that you would.
I'm bracketing those.
Okay, but bracketing those with respect to the Rehabilitation Act, I think you would. I don't know whether you need to have a disposition of denied or I mean, I don't think you would grant the Rehabilitation Act claim because we don't. If there's a mystery over exactly what we're asking for, but if you say we don't really know and there's a range of options and go back and discuss it with the agency, I think we'd be fine with that disposition. But I do think it would be helpful to sort of have some guidance from the court on exactly what you think appropriate accommodations would and wouldn't be depending on what they're asking for. So if what they're asking for, we would ask you to say, if what's being asked for is the option to go through a walk-through metal detector, that the answer to that is the government doesn't have to do anything more than provide what it already has, which is the pre-check option. But if he's asking for something else, which is, for example, the ability to go into a private room and disrobe, I mean, I think there's lots of reasons why we wouldn't want to do that. I don't know that they're security-based, but we haven't really considered that. So I think we could, but we'd sort of like you to know whether that's something that's the court considers to be an option, or if the answer is the only thing that's really on the table is you have to be exempt from a pat down under any circumstance. I mean, it's our view that under no circumstances can we agree to that.
One of the problems with this case is it's that it's on direct review.
Mhm.
Instead of before a district court where there could be it could be and should be evidentiary hearings dealing with this. The question whether an accommodation is effective is a material fact that has to be established by the plaintiff in the case.
Mhm.
And all we have are pleadings. We don't have any evidentiary findings or any of the sort.
That's right. And I think those could be gathered in an agency proceeding. And I think that was sort of our point. And I think the only question is whether you would, if you decided that what was required was that kind of a proceeding and you would remand for that, we would just ask that the court provide some explanation about sort of what's on the table and what you view about those things. I think that would be helpful for all the parties to know. I do also want to bring up one point, just so that everyone is sort of, I guess, aware of it. And I'm not quite sure what the answer is, but what happens after that proceeding with respect to future federal court proceedings if the petitioner is unhappy with the answer given by TSA. And we are here on a petition for review, and it's not 100% clear to me whether that's really the appropriate way to bring a challenge to agency administrative procedures under the Rehabilitation Act. I understand that in USCA, the First Circuit thought that that is how you bring the case, although if a careful reading of that case shows that neither party disputed it, and the court sort of, for lack of a better term, kind of glossed over the issue a little bit. And then subsequent district court cases in Mr. Muir's cases have held that Rehabilitation Act claims should go directly on a petition for review. And for some of the reasons that Judge Randolph said, I'm not sure that that's the correct avenue, that maybe a district court would better handle the fact finding in that scenario. And it's
Then you
also
have a claim splitting problem where there's a challenge to the statutory, I mean, given the combination of challenges in this case, one, the statutory authorization for the standard operating procedures comes directly, Rehabilitation Act goes separately.
Right, I understand that. I understood the premise of my argument was that you would, on this petition for review, dispose of those claims on the merits, the APA claim, and the only thing that would be left would be the Rehabilitation Act claim. And if that's the case, I just want to sort of be clear that it may be the case that the way you proceed after any future administrative proceedings is through district court rather than a petition for review. And the reason I want to make that point clear is because in prior cases involving Mr. Muir, the district courts have held that he should bring that case in the Court of Appeals, and they did so based on USCA, which I think did not maybe thoroughly examine the issue. And so I think that's an open question, and I don't want to be accused of sort of sandbagging later. So I just want to put that out for the court's awareness that it's not necessarily the case that if you were to remand for administrative proceedings, that it necessarily returns to you on the same petition for review. And I just want to be candid about that issue.
Okay, that's helpful. That's
Okay.
very helpful. Thank you.
If there are any further questions, I'm happy to answer them.
I think we're
Okay, thank you.
satisfied. Now, in terms of rebuttal, did Mr. Weaver reserve any rebuttal time?
Your Honor, just a couple of quick points on rebuttal. With respect to the Rehabilitation Act claim, the government's only argument that it has made is that it would be an undue burden to provide an accommodation to Mr. Muir. We've had a lot of discussion today about what precisely the accommodation is, and I appreciate the court's concern about that. But in the briefing, at the very least, the accommodation that Mr. Muir is in need of is access to the walk-through metal detector as opposed to the AIT machine, because that will significantly reduce the chance that he is subjected to a targeted, painful pat-down. And I would just emphasize that the government's rationale for why that type of accommodation would be an undue burden, and the government's rationale for why the standard operating procedures are not arbitrary and capricious is completely hollow for a lot of the reasons that we've discussed today. All the categories, or for many of the categories of individuals who are given sort of access to walk-through metal detectors as the primary option, the notion that there's some sort of visual indication necessarily indicating that they legitimately have whatever the problem is that causes them to go through that machine is wrong. It's not the case that for individuals who, for instance, cannot raise their hands, that is something that is not, anyone who is trying to get through and access a walk-through metal detector could act and pretend like that was the case. There's no way for a TSA agent to verify that there's a medical problem that necessitates putting them through the walk-through metal detectors. So amicus would just emphasize that I do think the reasoning on both the question of would primarily accessing walk-through metal detectors constitute a primary burden, and then is the denial of Mr. Muir and individuals in his circumstances of access to walk-through metal detectors as the primary screening mechanism, whether that's arbitrary and capricious. I think the government's rationale on that is illogical and violates both the arbitrary and capriciousness standard and then also the Rehabilitation Act.
We don't know how many people are similarly situated, how many people who use the airports are similarly situated to Mr. Muir, do we?
No, Judge Pillard, there's nothing about that on the record.
All right, thank you.
Thank you, Judge.
And did Mr. Muir reserve rebuttal time? You don't need to take it, but if you want to.
I would just say, thank you, Your Honors, for granting me permission to appear in front of you today, and I'll stand on my briefs. Thank you.
Thank you. And Mr. Weaver, you were appointed by the court to represent the interests of appellant in this appeal, and the court very much thanks you for your able assistance. Case is submitted.
This honorable court now stands adjourned until Monday, March 17th at 9:30 a.m.